Good morning.
Morning.
Are we ready to start?
We're ready to start. This is Senate Judiciary. It is September 8th, 2020. Meeting once again remotely. This morning, we're going to continue our conversations about S-119, which is a bill that passed the Senate during the second session of this year's biennium, and we're now in the third session, and the House has taken it up and has made significant changes and expansion, as well as the governor's executive order. It does deal with some of the things that we were dealing with in S-119, but it also deals with things that were in S-124. That is mainly a government operations bill that Senator White's committee is looking at. So today we have Julio Thompson from the Attorney General's office, the head of the division on racial justice. And I was hoping to get some information from Julio regarding both of those matters. One is the significant House changes that seem based on a Seattle law, as well as how he sees the governor's executive order fitting in with S-119 and S-124. But since S-124 is a government ops bill, maybe it'd be focused more on 119.
Okay, I'd be happy to do so. So for the record, I'm Julio Thompson, Assistant Attorney General, Director of the Attorney General Civil Rights Unit, talking with you this morning about S-119. As the committee knows, the version of S-119 that passed the Senate, passed with our office's support. We embraced the California, basically what's been called the California standard for including a necessary standard. We believe that the standard really applies to all uses of force by law enforcement, not just deadly force. And I think there's language in the as passed version of S-119 that extends beyond deadly force, which is a small subset of all the force that officers may use in their career. I think the reference to the executive order, it is pertinent, or I think it's related to the proposed language from the House, because what the House is trying to do, it appears, is add more detail to fleshing out the California standard, and to do that in statute. Typically, what's regarded as best practice in law enforcement is that the really detailed policies that identify the many different situations or try to address the many different situations that officers encounter in the field is really something you do through a policy, in part because the policies are amended and tweaked a lot more easily in light of real life situations that officers encounter in the streets. It's a lot easier to do that than to do that through the statute. And because Vermont's legislature isn't a full-time legislature, you could have situations where a department might, with community input, might want to refine its policy, but might be stuck in a period of time where they can't train away from a given standard because a statute is what it is. So I think that the idea, the core principle that all state law enforcement should have the same standards for their conduct, the same training that comes out of the academy from both the recruit and continuing education, is something we embrace. So it seems to me, if there's going to be a development of unified use of force policy, the material the language that we're seeing from the House would be something that you would normally encounter in such a policy, which would be broader even than the language that they provided here, but it would be part of that.
You're muted, Senator Sears.
How did some of the sections get in? It looked like what they did was we passed S219, and it appears I'm looking at the side by side, and a law enforcement officer shall cease the use of deadly force as soon as the subject surrenders or no longer forces an imminent danger of death. So how does a law enforcement officer, so you're permitting a use of deadly force until it's no longer necessary? I've had trouble with that piece. Also it appears to, a law enforcement officer may use a prohibited restraint in a situation where use of deadly force is justified. So it seems to undercut what we passed in 219. Was that part of the Seattle model, or was that something that they came up with on their own? Or?
About the use of a neck restraint?
That you can do a prohibited restraint if the situation warrants.
It's pretty, I don't have the Seattle policy in front of me. A lot of law enforcement policies within their deadly force policy or a subsection of their deadly force policy will address neck restraints. And those that prohibit it typically say you can't use it unless deadly force is warranted. In other words, if the circumstances are such that the law and the policy would justify the officer discharging his firearm, and there may be, and I think you've heard testimony early in the summer from Drew Bloom on the subject, there are circumstances where deadly force might be warranted, or there's the officer or someone else is in a near-death situation, and using a firearm would be more hazardous than using some other type of force. So I think the illustration he offered, for example, was two officers on the ground, or an officer and a suspect on the ground, and there's a struggle for the officer's firearm. And maybe the suspect has control of the officer's firearm, and then another officer has to decide under the circumstances what force to use before that gun goes off. And if the circumstances would allow that officer to discharge his firearm to strike the suspect and keep him from using the gun against the officer's partner, then the officer would be allowed to use a neck restraint, which carries with it, while it presents a deadly threat to the suspect, doesn't carry the risk of inadvertently harming the other officer who's on the ground, who might be struck with a ricochet or a stray bullet. So I think that is, under those circumstances, if an officer is faced with defending their life or defending the life of another person, you will see pretty commonly for policies that address that a prohibited restraint is permissible. And I think I don't have 219 in front of me, but I think 219 made reference to the self-defense statute, which would include defense of life. So you can defend your life or the life of another person by use of a neck restraint. That's the law that applies to every person in Vermont, not just law enforcement officers.
Right.
Self-defense statute.
I just want to follow up with one more question, then I'll go to Senator Brew.
Okay.
I think the concern that I have, and that of many, is we seem to have nationwide and even in Vermont difficulty holding what I'm going to refer to as bad cops, which is a very small minority of all the police officers in the state, but holding those folks accountable. And you know, I think there's been many cases where behavior has been extremely questionable, and we seem to have a hard time. So I guess, you know, that's kind of my response. And I don't want to do things that are going to continue to exasperate the situation where the rogue gets away with stuff when they perhaps shouldn't. I don't know if Senator Bruce was questioning the same way, but that's my concern.
Well, I really an informational question for Julio. Julio, if I believe 219 and 119 strike the justifiable homicide statute, and it was my understanding that a police officer, even without that, would have a remedy if they were on trial where they could make a self-defense argument, either from common law or some other area of statute. Is that true if we didn't add a protection here, or if the justifiable homicide statute wasn't available to them, that they could still argue self-defense?
I'm a little unprepared to really respond with an analysis of 219 since I was called on 119. I don't have that. I don't know if Bryn is able to, like,
Well,
I don't recall the language off the top of my head that that struck the existing self-defense statute.
well,
Vermont's-
whether it does or doesn't, isn't there always
Okay.
a remedy in self-defense?
Well, I mean, Vermont has another statute that says unless directed by the legislature, then the common law applies to Vermont. And so the legal question would be, I don't know the answer because I haven't had a chance to think about it, but the question would be, if language just struck a self-defense statute, then someone who sought, what does that mean? Does that reflect an intent to remove the self-defense standard that's available to all criminal defendants? That would be the question, really, because unless there was language that said the common law principles in Vermont for self-defense hereby apply. So whenever the legislature elects to regulate something or set a standard, and then it repeals it, the question for a court is always going to be, well, why'd you repeal it? What is the state of affairs that you intend?
But if there's another, if as you say, there's another statute that says in the absence of a proactive directive from the legislature, then common law applies, then striking a statute isn't the same as having a statute.
Well, I don't have that common law statute available to me. I mean, I was just paraphrasing it. But I mean, that would be the question, really, would be what the, and we do have ledge counsel here, so I don't know whether Bryn has, I see it. It is the 219 says that the justifiable homicide statute will be repealed next July.
Yeah.
So it's not repealed now. And the question just becomes what you replace it with. And I don't know that we have a view about proposed language for the justified homicide statute. So that's not something I can really address. I do think, I mean, in common law, and we have others on this panel who are more familiar with this than I am in the criminal context, because I don't practice criminal law. But in common law, if someone is facing, imminent threat to their life or the life of other people, then using force for the protection of self or protection of others, is a well-recognized doctrine. There are lots of variants of that central doctrine, though, such as whether you provoked the confrontation to begin with, what other alternatives you have to using the sort of force that you're using. And so that's why, some jurisdictions have elected to put that in statute rather than rely upon judge-made law for
the reason I bring it up is Senator Sears, I think, is exactly right, which is as we began to, as a society, as a nation, we began to look at why police officers are, practically speaking, never prosecuted for crimes like this or successfully prosecuted, is, in my own opinion, because over the years, they have successfully lobbied for layer upon layer of protection, union protection, protection by statute, common law protections, which were always there. So there are, if you're a prosecutor prosecuting the officer who choked George Floyd to death, you're facing an uphill battle. So we had a lot of discussion in passing 219 about if we prohibited the restraint, flat out, full stop, prohibited it, and an officer did use it in the last resort, it was my understanding that they would have a remedy at law, even without the justifiable homicide statute, which, as Julio pointed out, is due to be struck under 219. So just, Bryn, if I could just ask that general question. I don't think that we can, basically, I don't think we can get rid of an officer's right to make a self-defense argument in that case, unless we were to specifically prohibit common law.
You haven't, but I think Bryn is about to tell you why that is, because we
Okay.
only repealed section 3 of that justifiable homicide statute. But
Okay.
you asked Bryn, so I shouldn't
Yeah.
have jumped in.
Yeah, let's ask Bryn.
Good morning, committee. For the record, Bryn Hare from Legislative Council. I thought that it may make sense for me to start out by saying that some members of the House committee have worked on a new draft of 119, which I have just shared with Senator Sears. And it makes a change that alters this conversation pretty significantly. So I think I should share that if it's all right with the committee, which is that.
Good, please share it.
Okay, rather than repealing that subdivision 3 of the justifiable homicide statute, which, as you know, applies to law enforcement, it makes an amendment to that subsection instead. So it sort of rewrites that subdivision so it provides that some sort of harm or homicide that occurs as a result of law enforcement using force or deadly force that's in compliance with the new standards is considered justifiable homicide.
Can you share it on the screen, Bryn?
So I'm not a host, so I can't share it, but I
Okay.
can send that if you'd like. I can send that particular language to Peggy, and she can share it if that works.
Does it?
Yeah,
still
that's fine. It's somewhat unusual to have, and this is part of the reason that all of this is so unusual. We're dealing with a House bill that we may not have an opportunity to have a conference committee on, that we may only have an opportunity to do concur with further proposal of amendment, may not even have that opportunity. I've tried to talk with Tim about it. So it's important that we keep in close contact with the House. But I don't want to interrupt if Julio has any comments. But so if we could share that, Peggy.
I haven't received it yet, Bryn, but I did make you a co-host, so you might be able to share it.
Well, let me forward it to Peggy. And then you could forward it to every member.
I
Yeah.
just sent it. I just sent it to Peggy.
Okay,
So
well, I
that-
just did too.
Okay. And just to be clear, this new draft hasn't yet been reviewed by the House Judiciary Committee. There's just a couple of members of that committee that have been working on it over the weekend. So they haven't yet had a walkthrough of this new language, and Julio hasn't seen it yet. So it's just to make
Bryn,
sure
while
we
we're
understand.
figuring out how to get this document to everybody, can I ask you a question out of basic ignorance? S-219 is now an act, having been signed by the governor. Can the House come along with a proposal that we can subsequently in the same session revise a provision?
Yeah, so I think that you're speaking specifically about that prohibited restraint language. So because that, there are portions of that bill that don't take effect until later. In fact, I believe,
October 1st, right?
yeah, October 1st is a prohibited restraint. And I believe that that repeal takes place on July 1st of 2021.
Okay.
So yes, I think that the idea is I think the idea that everybody discussed was amending that language prior to it taking effect.
Interesting.
Do you guys see it now? I put it up there.
So
Yep.
Yeah,
if you don't mind scrolling down, you'll see that all of this language in yellow. I'm not sure that the committee has time to talk about all of these changes right now, but those
I
are
don't
all
think we
changes.
do. I still want to stick with Julio, but
Yeah, if you want
this
to
is a
just
crazy way to try to deal with bills, and I'm beginning to wonder if I did send an email this morning to Tim Ash with my concerns about this process. I am very concerned that we're allowing a bill to pass with significant changes as if we were a unicameral legislature. And I appreciate the House's willingness to keep us abreast of the changes going on, but it's hard to get testimony scheduled and then have, like Julio this morning, and then have a new draft already available that he hasn't had a chance to see. So it's very difficult. I appreciate Representative Grad's trying to keep in touch with me, but I am really concerned.
and Senator Sears, if I might, the other weird thing about this situation is that we're in September now. So, if this turns around and gets signed in this short session, it's going to come into force in October. So waiting until January is not a crazy idea, at which point we go back to a much more normal process. So I haven't seen the draft that was just shared. I haven't had a time to really look it over. It could be that it, rests really comfortably with what we did in 219, and I would feel better about it. But the draft we have been looking at, what's to be gained by rushing something in order to get a couple of months? I think honestly, the only reason to do it is to prevent provisions in 219 from coming into law.
Well,
Senator Sears?
Yep.
May I, I believe that, I think that the comments that you've made and that Senator Baruch just made are important. And I thought that we had heard from a number of people, including Mike Sherling and Susanna Davis and a number of other people, that trying to rush something through just to get it through is not necessarily the best thing to do, and that it might make more sense, as Senator Baruch said, to wait until January and really try to get it right.
We may not, yes, I don't disagree. On the other hand, I believe that this draft, and Bryn, I believe this draft tries to address some of the concerns that we expressed at our last meeting.
Yes, I think I would characterize two of the major changes as returning to the Senate version of the way that the standard or the policy describes prohibited restraint. It provides that law enforcement may not use a prohibited restraint for any reason. And then it, again, as I mentioned earlier, it does not repeal that justifiable homicide subsection, and instead it revises it to provide that law enforcement use of force that's in compliance with those standards could result in a justifiable homicide defense.
Well, that entire statute needs reworking.
Yeah, if
The
you
the reference to mistresses and masters and everything else.
Right, it does
also
make
needs to
some
be looked at.
other amendments to that language. If you look at section 2, there are some other amendments that are made to the entire statute.
That one,
Yeah, the justifiable homicide statute, and that's in section, I know it's not on your screen right now, it's in section 2. But it does update some of that language and make some grammatical changes that that should make the statute easier to understand.
can we come back to this on Friday? When Julio and others have had an opportunity to look at their proposed changes to 119 and 124?
That works for me. I don't know if
I'm asking anyone. I'm asking Julio, I'm asking you, I'm asking Peggy. I believe we have Friday open. We don't have an agenda item yet.
Mr. Chair, I'm available Friday if the committee needs me.
Yes,
That is correct.
Senator Sears,
Yep.
I have to, Friday, I have to take Bill for his post-op on Friday morning. And I don't know that they've made any changes to 124 yet.
well, okay. Well, why don't we just stick with 119 then? Because 124 is in government ops. So if we can
Is-
all come back together. Yeah,
Can I
Senator Benning, yeah.
I don't know whether it is, if the consensus of the committee is that we not try to force feed this through this year, I guess for myself, then I would be asking, why do we want to have an agenda item on something that we're not going to actually act upon? And I'll tell you personally, Dick, my law practice is falling apart around me as I try to deal with this extended session. I was really hoping we would be out of here by now. So adding things just to have something on the agenda to talk about is someplace I would prefer not to go. I'm going to defer to the chair's decision on what you want to do. But I just have to say that for myself personally, I don't want to spend time talking about something if we're not actually going to act on it. And I'll leave it at that.
My concern is we're the ones that kill this bill, and I don't want to be in that position for this session. And so I was hoping that we would be able to work something out with the other body that would get us a bill. And it seems like they've moved closer to our position on some of this with the new draft. So that's why I think it behooves us to not, as long as they're continuing to work on it, it behooves us to continue to work on it. And I understand that. I mean, in my personal life is also, I think all of us have been impacted. I've got I've got doctor's appointments and things, not this week, but next week, that are going to keep me from some of these meetings. It's gotten just, this whole idea that we can just drop our lives. The other thing I want to say is many of us have campaigns to run. And unfortunately, this extended session has given a tremendous advantage to non-incumbents. I think we saw that in the primaries.
Dick,
Yep.
I think that I might fall somewhere between you and Joe. In other words, what is keeping me curious about going forward is what is in this draft. So I definitely want to sit with it and look it over. So I'm free Friday, and I would be happy to be looking it over on Friday. But I know what Joe's saying about if the committee feels like we might go forward with something, then I think Friday makes sense. The other thing I want to say is, the House has made it very clear, as have a number of the advocates, that slowing down the process should not be a dirty word, because we want to get it right. I heard loud and clear from Michael Sherling that they really want this bill not to be pushed through, that they want more consideration. So I don't think we're in the same position we were in at the end of the last session. If we were to say that we were going to take this up in January, I don't think there would be an outcry, because what we're doing here is much, Michael Sherling kept calling it a statutory overlay, and that's right. And we should know exactly what we're doing. But again, the caveat of whatever is in this draft might be acceptable in a way that what I've seen so far isn't. So I can't really say one way or the other until I've looked at it.
Well, we'll meet Friday, and those who obviously can't make it, they can't make it, as long as Senator Nick and myself and Baruth are here. And Joe, if you need to take time away, take time away. And we understand. This is a citizen legislature. And I think as citizens, the expectation is that we, especially for those of you with another job. I don't have another job, so I'm retired, luckily. But those of you with another job need to be there too. So I understand that. Alice, you've been silent.
I can be there Friday. I am concerned that, doing this as we're doing it, just getting piece by piece here is hard to do, to get the whole picture and what's changing in what places and what those changes will mean. I am concerned about that. To be able to really look it over carefully.
Yep.
And I guess the other thing is, as I understand it, the whole House Senate Judiciary has not taken a look at this. It's just first it was one group. I don't know if it's the same group that's working on this now. It's not clear to me. Bryn, do you know, is it the same group of people that did the summer work?
Yes. It's, a couple of members of the Senate or the House Judiciary Committee have been sort of taking the lead on doing the work over the summer and now. And that's correct that the whole committee hasn't yet had a walk through this new draft.
Uh-huh.
In fact, this is the first time it's public. It hasn't gone even on their committee webpage yet.
I see.
Oh.
There could be more changes.
I'm going to suggest that we do try the 11th to look at where they're at. But that looking at that's 2 weeks from the date that the legislature is due to adjourn on the 25th. That should give us a pretty good idea if there's something that changes we need to make during the week of the 14th.
Okay.
And give us an opportunity to have input into those changes, and then we can make a final decision around the 17th. For example, what Joe just said, I've got a doctor's appointment on the 16th for minor surgery in the morning. Then on the 18th, my wife has a vision appointment that I can't miss. So, I'm going to be missing some of those days too. So we're all in that mode. And so I think we just need to make a final decision by the 17th.
Okay.
And hopefully, Tim, we can talk with Senator Ash about this and his thoughts on it. I have, as I said, I've sent him an email. I also have reached out to the CSG Justice Center and hope to hear from somebody from there in law enforcement as well. And Bryn sent them copies of the bill. But here's the problem. Bryn sent them copies of a bill that no longer is relevant. So. All right. Julio, thank you very much for spending time with us. I'm sorry it wasn't more productive. But
Okay.
sometimes they change things in the middle of the stream.
I understand.
Just
Okay,
when you
well-
think you're going downstream, you turn upstream.
Oh, well, I'll wait an invitation for Friday from Peggy.
Yep.
And I'll see you then. And
Okay.
and Brand, if you could send me, if you haven't already, the latest draft, and just keep the one that you were talking about today, and just if there are other drafts that come up from the House, just make sure I have it. I'll check them with you Thursday to make sure I'm current.
I'm sure that Peggy will post this version on the committee webpage, so it's.
Okay. Okay, very good. Thank you.
I was
Thank
going
you.
to ask you that. So you want me to post that now, Bryn? Okay.
Yep.
Thank you all.
All right.
Bye.
Thank you, committee. We're an understanding group. Whew. All right. Continuing with our it just never ceases to amaze sometimes. So continuing with our efforts to understand the budget for 2022 with breaking recommendations perhaps to the Appropriations Committee, we have John Campbell and Annie Noonan to present the state's attorneys and sheriff's budgets. Sheriffs don't have any budgets, right? Just doing away with them.
We've already
With
looked
their-
at those.
I mean, with their budget items, there's no need for them to be, they don't need any budget items, do they?
Annie, I'm not sure if you're being serious or not, Senator, so I'll just,
Well, I heard that they're broke, so.
everybody's broke. No, yeah, Annie has, I believe, she'll be addressed. She's right across the room from me, by the way. We're socially distant. We,
Okay.
in the office. I understand that you said that you were not employed. With your hat on today, I was just wondering whether they were thinking about bringing you up from the minors.
This is what's commonly referred to as a tank season. But we're doing it on purpose. I think the Yankees are doing it by mistake.
What can you do? What can you say? My Dolphins start on Sunday. We'll see what happens with them.
Yeah, watch out for Cam.
Yeah, it's going to be an interesting matchup.
It is. Anyhow, do you, in all seriousness, you have budget challenges that are going to be difficult from what the governor's office proposed for the Department of State's attorneys and sheriffs?
Yeah, first of all, John Campbell, for Executive Director of State's Attorneys and Sheriffs, thank you for inviting us here today. It's myself, Andy Noonan, and Barb Bernardini are in the office. Again, social distancing, so we can present this to you. You know, this year, you guys have an extremely difficult time. So does, of course, all the agencies and departments in state government, with trying to figure out how we are going to afford, or how we're going to be able to make it through the next year. And we've been sitting here and probably have adjusted our budget at least a dozen times, trying to cut here, cut there, because originally the exercise given to us by the governor's office was a 6% cut, and it was just impossible without cutting personnel, because I think, as all of you know, almost all of our budget for the state's attorneys is personnel. And there's others that is for depositions for experts and office supplies and the like, but the majority of our budget is all personnel. And what's truly difficult to try to figure out this year, and I think Joe can speak to this, is that we don't know what's going to happen going forward. Currently we're 6 positions, or 6 people short right now, 6 deputies. And the fact is that most cases are almost in a holding pattern, because the defendants, and no, I'm not complaining about this in the sense that I would, if I was their attorney, I'd probably recommend the same thing. Most of the defendants are they're in a wait and see pattern as well. because we try to see if some cases can be settled, some, but the party has pled guilty and is waiting, has asked for trial. So what happens is that when dike breaks and when we go back to do trials, then you're going to have a plethora of cases that all want to go to trial, and that's going to be so backlogged. The number of personnel that are going to be needed, both not just with us, but also the defense bar. I'm sure Matt's probably told you it's going to be very difficult for them to do their job with just the personnel once this thing goes back, and once people are asking for trial.
You were kind of breaking up there, John, at my end. I don't know if
And-
others were.
Yeah, and I'm sorry,
You were breaking up.
you froze up there. So
I did?
Didn't know if you asked a question.
No, I said
Oh.
you were breaking up on my
How about-
end, but I don't know if it was me or you.
Well, anyway, I'll just continue on. If there's, I got to put my, see you guys. So,
John, I can only hear about every fourth word of yours, and now you're completely
but
frozen.
the
and
governors recommend
I can't hear
to
anything.
Bill.
Annie, can you hear? If John can?
The
John,
again,
we
I'm
can't
sorry
hear
for
you.
being-
Yeah, we've lost you, John.
Annie, can you hear us?
And then also,
Peg,
Yeah. John, we're having a difficult time hearing you. You keep breaking up.
John,
Annie,
turn off your video.
I think you did, or
you go ahead and finish.
I'm wondering, can the committee hear me?
yes, we can hear you clearly.
Oh, boy.
Maybe if John will just turn off his video, we'll be able to just hear his
I
voice.
think so.
I
I
think you
think so.
did.
There we go. Do you want to use John, come over and use my computer. Switch. We're going to switch so John can come on my computer.
Does your department need new computers?
Yeah, actually, it's not computers we need. But I think I'm coming in over there, Andy. I'm sorry. We just want to lower the.
And now Annie needs to shut that computer off, or shut the mute off,
Yeah.
mute that.
Turn that one off. That just like the top sound button. Okay, can you hear me?
Yep.
Okay. So the matter is complicated by the fact that we have one domestic violence prosecutor in Bennington or Windham County, and that's in jeopardy at least for at least half time of it. And then the investigator in Bennington County, which that was all from a grant. We don't usually have investigators, but there was a grant that provided Bennington with that. If you recall, these were funded positions from the center, and then they reassigned all the different grants a couple of years ago. So we went out and found a grant to cover that. But unfortunately, that was tied to the language from the the DOJ had required us to put in, as you know, which I think you all put in S-234, which was given the victim of a sexual assault the right to ask that the defendant or the defendant after arraignment could be tested for the presence of HIV or other sexually transmitted diseases. which would have been a confidential, and the results only given to the victim, of course, the victim's doctor.
And S 234, we passed the language so that they would be made whole and that the federal government would approve it. The House Health and Welfare, the House Health Care Committee did not like the provision because one group complained. So they have threatened to take all of S-234 into their committee if it's not stricken. So you have a $40,000 hole. Is it for this year or for the next 3 years? Is it over a 3-year period? It's a 40,000,
Yeah,
or is it going to be?
It's over a 3-year period, which means that.
So it's about 15,000 a year.
Yes.
So I would propose that we urge the House, if the House puts in the 15K, to make those positions whole, or if they don't, I would propose we urge the Senate to do the same. Senator Probst. Does everybody follow what happened? The House took the language that we put in S-234 out.
Who was it that opposed it? I can't remember.
Here, you want me to explain?
Go ahead, John. Yeah.
So what happened was that went over to the House, and then the network decided that they were not going to offer an opinion, offer testimony in support of it, and had conversations with Maxine or with Representative Grad, where they were concerned because there were people in their organization in the HIV community that were opposed to it because they felt that it was stigmatizing to anyone who had HIV. This had nothing to do with with people who had HIV. This was limited strictly to a person who was arraigned and for sexual assault, and the results of the testing would be just remain with that person, with the defendant, and also with the victim. I kept on trying to discuss it with a lot of people, and then the organization, the advocacy group that decided that they were totally opposed to it, then they have asked, well, I'll tell you what, we'll come to a compromise if you give us $10,000 to come up with designing some programs for you. Then we can think about supporting it, which I find personally offensive. And there's just no way in the world that I would recommend that our department spend a dime on the situation. And I just find it important, actually, that it occurred. But again, that's neither here nor there. We're concerned about being able to provide people in Bennington and Windham counties with these individuals that are helping with domestic violence cases. So I think those are the most important. So however it's done, if the state wants to backfill the feds, that's fine. So I thank you, Senator, for doing that. But that again is just one of the needs that we have for the personnel, and Andy will go into that more in detail.
Well,
May I ask a question?
Yep.
So did the House not see this little bribery scheme here?
I don't know if they're familiar, if they were personally made aware of that yet. I have not discussed it with Representative Grad or anyone in that.
Well, it was Health and it was the Health Committee or Human Services, I thought.
Well, I think
no, it was the Health Committee.
Well, my understanding is that what we were told is that if it does go, if the House Judiciary Committee, if they had put that language in 234, then the Health Committee would take it into their committee. Because
right.
The committee chair was absolutely opposed to any of this type of language. Where it comes from, I could just give you a quick so you understand, because I was totally perplexed, this is a national movement where the HIV community is afraid that it's a slippery slope because there are 2 states, I believe, there are a few states down south that if you have been and if you've had HIV and you transmit it to somebody else, then you can be charged with a crime. Of course, that's not what we're doing, not even talking about that. I don't think that's right. I would not support any law like that. But I think they felt that this is just sort of a foot in the door, which, as we all know, I mean, that's the one thing you always hear about, the slippery slope. I just don't see it in this. I think that a victim who has been sexually assaulted certainly has the right to know whether she's going to be tested. And the discussion goes on. It's a lengthy discussion, probably too much for right here, but I'd be more than happy to share with you or talk to you offline if you want, Senator.
I think we should move on.
Yeah.
Are there other areas of the budget where you need money that didn't get appropriated by the governor,
Yeah.
or may not be in the House bill?
Here's where I think our biggest pressure comes outside of that, and this pressure is one that will not only affect us, but its tentacles going to reach are going to be far-reaching. And you all are familiar with it, and that is with their case management problem, the case management system. We were told by our vendor currently, Journal Technologies, that as of June next year, they consider this system to be outdated and will no longer support it. Even more complicated than that is that they will not create any what's called security patches. So Mark Coombs, who is the head of the for ADS, who's head of the tech there, said there's just impossible for us to have this on the state system at all without security patches. Also, we've been working with Dan Smith from Joint Fiscal, because this involves interaction with the courts system, with their Odyssey system. Without this case management, we will not be able to integrate completely with them, and it's just like it's nonstop. We have talked to Tyler, who is actually the manufacturer for Odyssey, thinking that what the best way, as you all know, some of the problems that we've been encountering, is go with Tyler, because then you have a fully integrated system. Everybody, the computers are all talking to each other. They're talking the same language. And so we were looking to go to them, and they can make the total conversion for us, but it's going to be 1.4 million over a couple of years. Andy will go over that. And right now we have about 350,000 that we can put towards that. But we have to make a decision almost immediately, because the vendor we have is now telling us they're not going to host us any longer if we don't upgrade to one of their programs. And honestly, we had a conference with them, a phone conference or a teleconference like this with them the other day. I've been very concerned about their management and about the strength of their company for a number of reasons, but the call did not make us feel any better. Let's just put it that way. So if we get stuck in the middle of nothing, then everything comes grinding to a halt, because then we won't be able to go in and do any electronic filing, and it's going to be extremely problematic. Unfortunately, this was not something that we saw happening, because we didn't think that they were going to all of a sudden stop. We just found that out I believe, Andy, was it February or March that we found that out, right before the pandemic. So that's our next biggest pressure. I won't go into the little ones. I'll let Andy tell you the ups and downs, but that one certainly is one where we did put in for COVID funds, and I believe very sincerely that they should be go to that, because this involves all the remoteness that we're talking about that we're going to probably have to do for the next few years, and we can't do it unless we have this other system. So, but the problem with the COVID funds are spending it in time. And now
I don't need to go. I don't need to go through we don't need to go through the ups and downs. We just want to know what above the governor's recommend you would.
If I could have Andy will go ahead and address these numbers then. Oh, okay, come over here. Sorry.
We got about 5 minutes left, so.
Great, thank you, Senators. Good morning. They don't want the ups and, okay, I'm sorry, and I didn't hear your question. So I think probably the most important thing is for us is the current vacancies and how to figure out if there's a way to get some funding to fill those. John mentioned the two biggest pressures for the department are basically being down 6 positions since 2018. We have 4 vacancies, which we were originally budgeting for this year. They were in our budget. And then as a result of some of the cuts, it looks like we can fill only 2 of the 4 that we had planned on filling this year. So that will leave, there's tremendous pressure on those offices, but we also know that there's pressures in other offices with our caseload numbers are just going up and up. We did get some relief from the state finance and management. They gave most of the departments some relief on their internal service fees, and that was helpful. And that came to us to be about $37,000. But really, what we need would be money to fill the additional 2 vacancies that we have. And then, as John mentioned, this whole issue with the case management system, we have only about $300,000 that we could put towards it. We are working with both Joint Fiscal Office and with ADS to put together an RFP, but we do have a pretty good sense of what an integrated system with the court might look like. And John is correctly quoting that it looks like it might cost us upwards of about 1.2 million. That would be obviously something we had hoped originally that we would have some ability to cover that through COVID funds, but as you know, December 31 is quickly approaching and those monies need to be expended by that, and you can't pay for things. The feds will not allow you to pay for kind of upfront for certain things. So we're really struggling with all of that.
We're hopeful that those rules will change, that Congress will do something between now and then, and that would give this. And my understanding from Representative Welsh is that Congress is pretty well aligned to at least give more flexibility on the CARES Act funds that we've already received.
That would be really great. And one of the things, senators, that we did receive, so I think you probably know that a lot of the courts are doing things remotely. We did get approval and are working towards getting Cisco endpoints put into our offices because we were not able to, we didn't have that kind of technology, and we were able to do some upgrading of some computers in the field for people who also had 5- and 6-year-old computers and were not able to effectively remote in. So we are able to do that. You heard through some of your other, I think some of the senators on this committee have also heard some of our challenges with just the workload pressure that has come to us as a result of the court's new systems, and those are real. You know, our estimate in some of our offices is the filing issues are creating a lot of administrative work. But what we really could use would be assistance with getting our 4 vacancies filled and potentially some support for our IT need. As John said, that we are in no, you know, we're basically out of commission with a system this coming June. And that was sprung on us and all the other users, you know, that this company has in the field. We all learned about that at the same time by a letter saying we're dumping that project. We've considered it an aged out project, so we're not going to support it anymore. We have asked them if they would work with us on a deal to give us some tech support for a year. They told us they are not inclined to do that. And I guess they are trying to push people into their new product, but we really aren't at a point of making that decision yet. So that would be good news, Senator, if the federal government would give us some more time to spend some of that COVID money, but the CARES Act money. But right now, the amount of money we would really need to help us get those other positions filled. If we were only talking, you know, the last 2 of the 4 would, if we probably we would need about $270,000 when you're loading in salaries and benefits, all expenses. Well, that's
Are you requesting 270,000 above the governor's recommend?
To fill the 2 that we don't have any money for, Senator. That's our best projection about what we would need. Yes. So the answer on that would be. John's saying I'm not allowed to ask, so I don't know. Are we asking? Yes, yes. I'd say yes. I mean, and then John can fire me later.
Well, all right. So for the committees, the three things you're asking for are 13,000 per year for the next 3 years for the Bennington, Wyndham County State's Attorneys,
I think it's,
And-
yeah.
270,000 for 2 more positions over what the governor. So you're down 6, you're filling 2, and you'd fill 2 more, so it'd only be down 2.
We'd be
That
down. That's
math add
correct.
up? Okay.
That's correct, Senator. We're down 6. We have enough money to fill 2 in our own budget. We would be requesting enough money to fill 2 more. I mean, preferably, we would like to fill 3. That would be our best situation now, but we didn't want to seem greedy.
I will, does the committee want to weigh in on these 3 requests? Which the second request is really, we don't have much at this point to do with because it's pressure on a system. And obviously, we've had little influence on the judiciary's Odyssey system.
Us too.
Right. I would say that for Windsor County, yes, they're having a hard time because they're down positions.
I'm just asking committee, do you want to recommend to the Senate Appropriations Committee that they fund 13,000 per year for 3 years for the TV positions and 270,000. I don't know whether the committee will find, the Appropriations Committee has the money, but 270,000 for 2 more deputy state's attorney positions. I know that Matt's going to come in and ask for 400,000 because tomorrow Matt Valerio has a because of care, what was going to be CARES Act funding is not has been ruled not appropriate, so he has a $400,000 hole. So,
Senator Sears.
yes,
I think that I agree that they need this money, and I would be supportive of recommending that the Appropriations Committee look at it favorably. I also realize that probably the other committees that we serve on are also asking the Appropriations Committee to put additional money in other areas. So I would support this one and then leave it to the Appropriations Committee to try to figure out how to do that.
well, since 2 members of this committee are on the Appropriations Committee,
I'd like to put it on the list.
we'll put it on
Put
the
it on the
list
list.
and see what happens. There's no
Yes.
guarantee, but at least it'll be on the list.
Yes.
Do you want to say anything else, John? Oh,
Joe or
Okay.
Phil, do you have any comments on that?
I don't.
Anything else, John or Annie?
no, Senator, I will just say that our other 2 sections of the budget are SIU. We feel we can manage with what we have in front of us for the year. We've talked to Mark Mater, and I think Mark's able to manage that. The sheriffs, their rescission was about $145,000. Their carry forward was 102. They've been obviously in an unusual year since the courts closed down. Most of the senators know that what we pay for from the money that comes to the department is the sheriff's salaries and benefits are paid out of our appropriation, as are the 25 state transport deputies. Since the courts have been idled for in-person, and we have not been moving folks from the correctional facilities back and forth, most of what, although there have been some extraditions and there have been some travel, but it's much limited. The other thing that they have been able to do, because the statute provides that for them, is that the state transport deputies, when they are not engaged in transportation, are permitted to engage in general law enforcement duties in their counties. And we've been working with the sheriffs to make sure that they're clearing those those assignments with us to make, so that we're watching to make sure that there's not any type of, double charging, charging a private contract and then being on the state time. So we're working closely with the sheriffs to make sure that they're using our state transport deputies properly. Some of them are doing the monitoring of the hotels and motels where they've put up homeless people. The proprietors, that was part of the deal, that they had to have some law enforcement presence. So the sheriffs have been doing that. They've also just basically been involved with some of the work around the schools and the school districts, being on the campuses of the schools to, watch and provide some security support. And then just generally having a presence in the local communities, which I think is very important right now for a lot of the small communities to have some of the presence of the sheriffs being available. So we've used them. I think most of the departments have been very, very active in terms of using them. Some more than others, but we're looking at all of how that's happening. So they will be able to manage under their budget, the budgets that have been presented to them for 21. We're confident we can manage those budgets. So there's no asks in either of those two areas, senators.
I appreciate that. Thank you very much.
You're welcome.
Thank you,
I
Senator.
wasn't aware, I am concerned about the use of the sheriff's transport deputies in general law enforcement and how that's all playing out. So hopefully the auditor of accounts will be looking at that.
I do talk with Doug Hoffer. He calls me pretty regularly. We do check-ins back and forth, and I'm aware of the auditor's questions and concerns, and I try to guide the sheriffs based upon
Well,
my
I'm
conversations with
concerned
Doug.
that, for example, if the sheriff if the sheriff of Rutland County has a contract with Wallingford, is the Wallingford contract being covered by a transport deputy who then is, and this whole thing needs to be, that would be my concern.
I think we agree that
Or is the sheriff of Rutland County putting two deputies, one the contract and the other one of his transport deputies in Wallingford, and providing extra service to that community?
we agree that I think the statute has not been particularly clear with what we expect, and I think that the executive committee of the sheriffs agree a conversation at some point to clarify the roles and responsibilities and what they do when they're not transporting, what we would like them to do. I think that we would agree that that's a proper conversation and a long needed conversation for us to be having with the legislature and with the auditor.
Senator
Yep.
Sears.
Yes, Senator White.
I just have to say that the whole way we fund and provide access by the sheriffs is just the craziest system that was ever devised. And it was as if we put some people in a room and said, come up with the most insane system you can think of. And this is what they came up with. And they ran into a lot of issues around that were made clearer because of the pandemic, that they're not eligible for certain things from SBA, for example, because they're considered government, but they're not, they weren't eligible for PPEs because they were considered government, but they're not eligible for other things because they're considered entrepreneurs and businesses. So they're caught in this really odd bind, and I think we need to look at the whole way.
Well, I think it's more
deal
than
with
an
it.
odd bind. In my opinion, it's more than an odd bind. You have a situation where you have officers funded by the state, 25 officers funded by the state, who are under the control of the sheriff, who can use them in various manner. And when the state's not transporting prisoners on a regular basis, those officers are out doing other stuff that the state is paying for. It doesn't make sense. And any other, I mean, if it just is and so I'm concerned at this situation, and I'm not suggesting that any of our sheriffs would do this, but it would be pretty easy to, you've got a sheriff who's covering a hotel. I've heard from sheriffs that Lamoille County had to cover Chittenden County's hotels because Chittenden County wouldn't cover the hotels. So how does that work? And what were those transport deputies doing?
Yes, I believe that that's accurate, and I'm not sure why the Chittenden County sheriff's deputies were not engaged in that. I think that, I know that Sheriff Marcoux was, and Sheriff Shatney, and I think Sheriff Harlow were sending folks. And I think there were potentially some other sheriffs. I'm not exactly sure. I know that, one of the things that has been really interesting as I look at it, in how the allowances for both state and federal provisions for the COVID no work have played out, is that employees have been able to identify, ask for FMLA leave for situations where their daycares were closed or their schools were closed, or they themselves had concerns about pre-existing conditions. So I think that there have been some of the transport deputies have been on the COVID charge, what they call the COVID no work charge. And I have not looked into each of their reasons.
Well, I don't think, but that's all I'm saying is that if the Chittenden County Sheriff refused to provide the hotels with deputies and the Lamoille County Sheriff did, what happened to the Chittenden County transport deputies?
I believe, Senator, from what I've seen, I think most of the Chittenden County Sheriff deputies have been on the COVID no work charge code.
Great. That's just great. I think we're digging a hole deeper and deeper, so maybe we should stop digging and climb out of the hole.
So I think that's all I have to share. I did send Peggy our up and down, and I sent Peggy a sheet that had our budget for the past few years, plus what the rescission meant for us carry forward. And I agree with everything John said in terms of our needs are pretty much just our personnel filling, our dealing with that federal cut. And obviously our IT need is going to be the big driver for us coming up.
Okay, great.
Thank you, senators. Have a good day. Thank you. John says he got cut off, but thank you very much.
Thank you, John. Sorry you got cut off.
No problem.
He's got a fancy computer. I got an old workhorse.
Well, yours works.
Mine works. Okay, thanks, senators.
All right, committee, thank you very much.
Thank you.
Committee, my plan is to go over the 4 items that they raised and ask the Appropriations Committee to also consider having the auditor look into the use of transport deputies during the pandemic.
Okay.
Is there opposition to that?
No.
Okay. Peggy, we'll adjourn for the day and get back tomorrow morning at 10. Is our agenda pretty well set for tomorrow?
Yeah, tomorrow we're all set. We have H962 and everyone's been confirmed, and then Matt's coming in to do the budget.
Okay, good.
Thursday, we have S119. We have Michael Sherling and Colonel Birmingham coming in.
Good.
And then Friday, we have S119, Julio Thompson.
I think would you just send a note to Michael Sherling that we'd like a discussion about how they see the governor's order, that sounded like a Bostonian, the governor's order, how it impacts S119.
Okay. And were there any other witnesses, Senator Sears?
And I
for
guess we
S1?
should provide them, everybody with the most updated version if Bryn could,
Yeah.
so that they're not talking about last week's version.
Yep, okay.
And
were
if
there
I
any
hear
other
anything,
witnesses On
well, if
S1 119, let me know if you.
if I
get
hear, I
anything.
will. The only ones that I would think of would be people from the Justice Center, if any of them
Okay.
have got.
Okay, let me know.
All right.
Right.
Thank
Bye,
you all
everybody.
very much.
Thanks.
Peggy, can I
Bye.
ask you a question? Peggy,
Sure.
can I just ask you a
Let
question?
me end the live stream first, okay? Do you want me to
Yes,
end the live
thanks.
stream?